All right, everybody, it is now 1 p.m., so we're going to go ahead and get started. I'll just keep monitoring the waiting room as we continue to let people in here, but we're going to get started so we're on time for everything. Welcome back. If you were logged on for H-2A this morning, thanks for signing up for both trainings. We appreciate it. Welcome if you are joining us for the first time today. My name is Emma Harbaugh. I'm the training manager for the Michigan Works Association. I just have a couple of housekeeping things. One, because of the size of the class today, I would just suggest keeping your camera off and muted. That will help with your connection. My job today is to make sure that I monitor the chat throughout both presentations that we have going on to make sure that we get all of your questions answered. Pretty commonly, I do get asked if the PowerPoint presentations will be shared after the trainings, and they will. I'll be sending a follow-up email with both the recording of today and the PowerPoints that we're going over. And I think that's it on my end. I'm gonna turn it over to both Ginger and Ricardo, our presenters today. And if you need anything, I'll be here in the background. Thanks.
Good afternoon, everyone. My name is Ginger Vallejo, and I am the manager for the Office of Foreign Labor Services with the Michigan Department of Labor and Economic Opportunity. I also have with me a couple of the Office of Foreign Labor Services team. I have Mercedes and Esmeralda. I'm not sure if they're able to turn on their cameras and give a quick hello. But if not, I'll go ahead and pass it over to Ricardo.
Hello, good afternoon. My name is Ricardo Caudillo. I'm a investigator with the Wage and Hour Division at the U.S. Department of Labor. And I will be speaking about the H-2B program during the second half of this presentation. And we also have Christopher Downing from our Detroit District Office.
Thank you, Ricardo. It's good to join you all today. Ready to get started and see if there are any questions or concerns. Ricardo is very knowledgeable in this, so hopefully it'll be informative for everyone.
Thank you, Ricardo and Christopher. I will take the first part and then we'll transfer it over to Ricardo. And I will be turning off the video to avoid any lag. Okay. Hello, everyone. Just a quick disclaimer. This presentation or document is intended for training use only and does not infer any legal opinion. Got to start off with the good stuff. So today, the second half of our webinar, we will be focusing on the H-2B temporary foreign labor non-ag labor certification program. So we will provide an overview of 2022 and 2023 fiscal years, an overview of the job order requirements and insurances, and then provide recommendations to ensure prompt processing of your H-2B job order. I also want to say real quickly that I believe our neighboring friends up in the Indiana Office of Foreign Labor are joining us today, so I wanted to give them a quick hello. All right, so let's start with the basics, who we are and what we do. The Office of Foreign Labor Certification, our central requirement is to determine whether there is sufficient, willing, and qualified workers available to perform temporary and seasonal employment, which the employer desires to import non-immigrant foreign workers. This is specifically how this varies from H-2A is H-2B is non-ag. So our core functions are to review H-2B job orders for compliance with relevant state, federal, and local regulation, provide training to Michigan Works and State of Michigan staff about the role within the H-2B program, provide order holding offices, job order recruitment information, post review and edit job opportunities on Pure Michigan Talent Connect, and complete post certification checks. The complete post certification checks is something new, and we're working on a process but the draft of it consists of emailing emailing the employer a letter of notice that the Office of Foreign Labor intends to complete a post-certification visit. And please excuse that it says field check, it should say visit, and informing of the times and dates that we will be out there. So just a quick notice on that that is a change for us, and it is something that we're working to implement. So I'm going to talk a little bit about H-2B in Michigan and some of the historical trends. As we know, that Michigan has relied on the work of H-2B workers to fill the gap in our hospitality industry normally. But in the last couple of years, the trends, we've seen increases in employer occupations in variety of occupations. I'm sorry. The number of workers has also increased significantly to the degree that it has prompted the U.S. Department of Citizenship and Immigration Services to increase the cap for H-2B visas in each of the last 5 years. And as you all might know or remember, this year, the total cap of visas was released at the same time. So these are some modifications that happen year to year so that the gap for workers is completed and then there's no disturbance in those occupations that rely on the H-2B workers. And if you have any questions, please feel free to write them in the chat or just bring attention. I don't mind stopping and answering if I have that information available. So these are the historical trends continued for the state of Michigan. For the use of foreign labor programs, Michigan has been in the top 10 states and has held in between number 6 and 7 for 3 of the last 4 years. In PY 23, the increase in foreign worker applications, along with changes in regulation in FLAG, has changed some of our review process. This includes additional language of employer engaging with their America Job Centers for where the state of Michigan is, Michigan Works. We at the Office of Foreign Labor Certification Services continue to keep up with regulation and work with our partners to process all job orders in a timely manner. And right here is just, I gave a little bit of just detail of some of the top cities and the top 5 occupations. Previously, Michigan had relied heavily on landscaping, maids, any of the occupations that are related to hospitality, but as you can see, some of the other ones, amusement parks, and we are starting to see some of the food processing in the state of Michigan apply for H-2B. Well, I'm going to go over what is the process, and I want to share this so that employers can know what the process is once their job order has been submitted. What is our role, the role of the Michigan Works, and then the Office of Foreign Labor Certification. So we're going to start with the role of the AGC. So they are required to post the jobs in the labor exchange system to assist employers. With the new rule, it requires, that was shared on May 2002 and implemented on January 6, 2023, requires employers to contact their local Michigan Works agency to seek assistance in posting job orders and with recruitment and referral of U.S. Job seekers, to file an application for H-2B certification for temporary non-agricultural workers at least 15 days prior to the intended date of filing the H-2B application. So with this being said, these are some of the duties that the Michigan Works Office are tasked with in helping. I do want to let you know that in the bottom of this slide, if you see the H-2B contact list, us at the Office of Foreign Labor Services, we keep an updated list of the order holding contacts for the Michigan Works. So if you are wondering who would you contact for assistance, that would be the appropriate list. And we also have it on our website. So what is our role? Our role as well is to review the H-2B job orders posted by employers on mitalent.org, which is the Pure Michigan Talent Connect. In other words, the state's labor exchange system. So we communicate with U.S. Department of Labor, Office of Foreign Labor Certification. We coordinate with AJCs and complete post-certification site visits. What we communicate with the U.S. Department of Labor might be any notices of deficiencies, unlike in H-2A where we do an official letter and we send it out. With H-2B, we are required to post a note on flag to identify the deficiencies and let Office of Foreign Labor Certification know that we've identified a deficiency. So if you, on the other end, are getting a note with that information, it will detail what the office has identified is missing from the job order. Okay, for reviewing the job order. For us in Office of Foreign Labor, this is what we're looking for. You know, that the employer will offer terms and working conditions normal to U.S. workers working similarly employed in the area of intended employment, which are no less favorable than those offered to H-2B workers. The job order must be posted on the Pure Michigan Talent Connect, mitalent.org. The reason for that is Pure Michigan Talent Connect will provide you an opportunity to register your federal employment ID number or employment ID number. And then would allow you the opportunity to post the job. This is a way of us knowing as well that you've completed the first initial process of working and creating your account on the Pure Michigan Talent Connect. It must meet all the regulatory requirements. And there's 18 assurances, which I will share in the next slide. And then we also double check the wage that is being offered to ensure that it is meeting what the Office of Foreign Labor Certification has given us for the type of occupation. So as I mentioned earlier, these are the 18 conditions of employment. We do get the list and we review it individually with each job order. If we identify deficiencies, I mentioned it earlier, we have 6 days to notify you, and the notification will come in via a flag note. That is the process that's been established. If we get an email or there's a need for support, we definitely do take those as well. However, we try and work as much as possible to stay with the communication within flag. So this way we can keep the process moving. Just want to let you know that with the changes in flag, we also have the ability, if it does not meet the compliance of the 18 regulatory ones, then we have the ability to not approve the job order until it has been remedied. And usually what we get is an updated job order, and then from there we will see if they fixed and added all the requirements that were identified on the notice of deficiency. So here's an example of a notice of deficiency. We sometimes get these drafts, which indicates, that the job has been posted and it's either placed on hold or it has been activated and deactivated, but they send in the job order draft. We need the Pure Michigan Talent Connect job order. This, if you look at the difference in the screens, when you complete your job order, you would activate it, save a copy that includes the job code number, and that is what we ask that you submit with your when you're completing your initial application and you adding it on flag. So if you can see the difference, it's all the same information except this one. We know that the employer is on the Pure Michigan Talent Connect, and we know that they have entered their job order information on there. So again, a lot of the questions we get is, well, we kept it in draft form because, you know, it cannot be activated until we receive a notice of acceptance. And that's true, but we need it activated so it can create a job order number. And then once you do that, you can there's a drop down box and you can deactivate it. And again, you know, per final rules published in May 2022, the employer must contact a Michigan Works office. Does not mean that our office is not available to provide support, but we just want you to utilize that resource that's available for you. Are there any questions?
We do have one question in the chat. Thank you, Eric. It states, some states will look at job orders early and suggest corrections before the flag process. Would Michigan consider this?
That is actually a really good question because we're in the process of establishing that. One of the things is that we received 582 job orders on January 2nd of this year. So in order to kind of streamline our processes, one of the things that we are considering is, and learning from some of our partner states, is that a lot of them do that. And it seems like a really good process to anticipate and to have ready. So definitely it is something that we are considering, but because we're engaging our Michigan Works offices, we don't want to just make a decision. We want to have a process in place. But yes, we are considering that. We just have to ensure that the procedure that we're creating works for us and that our Michigan Works partners are prepared to handle that workload. But thank you for that question. Okay. So, and then let me go to the next one. Another one is incomplete job orders. So we will have job orders that do not have the information, and we're not sure if the Office of Foreign Labor, whether it's because of the flag changes that we're getting more of these, or if it's just new employers that are needing more information on the particular jobs. Because when we look at your flag account, we'll see all the details. But when we review the job order, they're not on there. But we do not have the ability to modify your job order with what's on your flag account. That is the employer's responsibility. So this is just a reminder, you know, if you want that checklist as an employer, we'd be more than happy to share it. We do have also a like a pseudo job order that kind of lets you know some of the language that's regularly used for each requirement. So that is something that we've done to kind of help the employers be more prepared when applying for H-2B and having as much detail as possible. When the Office of Foreign Labor Services has reviewed your job order and found it does not meet the requirements, again, the analyst will provide details of the deficiencies and inform the employer via flag. All right. So the deficiency resolution, again, there's two methods that we work with. Either the employer works with the CO or with us and they update a job order that meets the criteria, or they provide the information to the SWA to update job order. The most effective and time-saving one is for the employer to work if they're working with an agent or with yourself or with the Michigan Works, to make sure that your job order is compliant, because we get pretty bombarded at the beginning of the year, and usually that lasts until the beginning of May, where we're still catching up, trying to make sure that every case has been seen, that our data keeping process and record keeping processes are updated, and that we're not missing anything. So that way we're compliant and we're also providing you that customer service piece. Once the job order meets all regulatory requirements, this is when we start working with our Michigan Works and providing that information. We will notify NPC via flag. Like I said, this recent changes in flags allow us to notify the certifying officer on the case from the Office of Foreign Labor whether the job order has been approved, not approved. So once it meets that regulatory requirement, we will update the flag decision to approve, and we will put a notice that the new job order, and we state the job order number, is meeting the criteria. So then this is when the Office of Foreign Labor Certification takes over. And these are some of the steps. But I want to jump quickly to the next slide because I want to inform of how we distribute that information throughout the state and our partners so that they know that these jobs are available. So again, once we receive the notice of acceptance, we work with handling the intrastate recruitment. Okay. So these are the steps that we take. Once we receive a notice of acceptance, usually the employer, and if there's a represented agent, and our office will receive an email that identifies that the notice of acceptance has been issued. We, on the Office of Foreign Labor, receive that notice. We will update the job order that has been previously deactivated. We will also create a referral log and provide that information to the order holding offices. Order holding offices are the Michigan Works in your area of intended employment. We let them know that these job opportunities are available. We provide them the steps of what, how to refer an individual, and then how to respond by providing that information to us. As you can see in the highlighted, it will provide the job order number, the employer name, and up to what date the recruitment they're responsible. After that date, we are waiting for them to send us any kind of notice that there has been a referral. We do keep track of all of that within our office. And what's a little bit different from H-2A than it is H-2B is H-2A jobs are usually open for recruitment up to the 50%, whereas in H-2B, the position is only open 21 days before the date of need. So there's a little bit of difference there. And those are the kinds of things that, as we work with our Michigan Works partners and our other department and the outreach team, we keep them informed of those differences so they are aware. Is there any other questions or information? No?
No more in the chat.
Okay, perfect. So then what is the process for H-2B orders? Once there has been a notice of acceptance, well, the interstate clearance order comes in. Then once DOL, Office of Foreign Labor Certifications, issues notice of certification, they do another review. So it's very important to just realize that maybe at one point they might send another notice of deficiency. So any communication will be sent to them. But once you are certified, then the process of getting your workers under the H-2B visa starts. I mean, this is when you will work with the U.S. Citizenship and Immigration Services to obtain those visas. And these are some of the support emails or pages for H-2B. Once your application has been approved by us, we are no longer have the ability to make changes or access any of the forms. Any and all changes in that with your in regards to your application would need to be submitted to the NPC. And I do want to again say that for employers, we will be sending out notices for post-certification visits. So keep an eye out for that. And if we don't hear a response, we'll follow up with a phone call just to let you know. And so the visit won't be too much of a surprise. And in this visit, we will be sharing, we will be working with the employer and with randomly pick some workers. Okay, just some last minute tips and just a rerun of what we talked about. You know, we want to make sure that the job order is posted on the Michigan Talent Connect. The Michigan Works agencies are there to assist you. I do have the contact list for the individuals in each county that are there assigned to assist. And want to double and triple check that your job order contains the 18 conditions of employment and that they're clearly detailed in the job order. Make sure the company contact information for referring and hiring is accurate. Failure to answer calls or emails from applicants can result in a negative action. If you're using an agent, make sure power of attorney or agency representation documents are all executed. All communication intended for us should be emailed to the leo-flc office@michigan.gov. And last but not least, be patient with one another and let's work together to ensure your foreign labor requests are processed timely. Is there any other questions or information before? If not, I just want to say thank you for taking the time to join today. I hope you find this information useful and look forward to working with you. I also want to give a special thanks to the Michigan Works Association for sponsoring this webinar and to Ricardo and Christopher from U.S. Department of Labor Wage and Hour for their collaboration. Last but not least, I have to throw in a plug-in. We have a monthly newsletter that provides updates from the Office of Foreign Labor, also provides things that are happening in the foreign H-2A or H-2B foreign programs and the outreach programs. If you're interested in signing up for the newsletter, we only send one once a month. You can go into the www.michigan.gov/AFLS and you will find the link to register for the newsletter. Thank you for your time. I'll pass it over to you, Ricardo. Thank you.
All right, thank you. Good afternoon and welcome back for those who saw the H-2A presentation. I am going to start sharing my presentation. Okay, and can we confirm that that presentation is up?
Looks good.
Yes.
Okay. Again, thank you to the host for inviting us to talk about the H-2B program. And this PowerPoint presentation is available through the Wage and Hour Division website. A copy of the presentation will also be provided to attendees. I may not spend a lot of time on some slides, so feel free to ask a question if you would like more information or to clarify a slide. The Wage and Hour Division enforces and administers a number of federal labor laws. This presentation is about the Immigration and Nationality Act, or INA, which authorizes the lawful admission of temporary non-immigrant workers. This presentation will summarize the H-2B obligations and assurances, identify common violations, and talk about how Wage and Hour Division conducts investigations or compliance reviews. This executive order has been rescinded. The section of the INA that refers to non-agricultural labor or services of a temporary or seasonal nature is H-2B. There are a number of federal departments and agencies involved in the H-2B program. My agency, the Wage and Hour Division, enforces contractual obligations related to the recruitment of U.S. workers, wages, and working conditions for H-2B workers and protected U.S. workers. Recruitment. Employers must make good faith efforts to recruit U.S. workers. This means submitting a job order to the State Workforce Agency, or SWA, and contacting U.S. workers from the previous season. This presentation is a little dated. There's no longer a requirement to place newspaper advertisements. But lastly, on this slide, employers must also make and keep a record of their recruitment efforts. Employers must hire any U.S. workers that are available and eligible. Employers cannot impose any restrictions or obligations on U.S. workers that are not imposed on H-2B workers. As an example, requiring U.S. workers to have 2 years of experience. However, there is no experience requirement, for H-2B workers. That would be a violation. An employer must offer U.S. workers terms and working conditions at least as favorable as those offered or provided to H-2B workers. Employers cannot lay off U.S. workers before H-2B workers arrive. And if lawful job-related layoffs are necessary, employers must lay off all H-2B workers before laying off U.S. workers. The offered wage must equal or exceed the highest of the prevailing wage obtained from the U.S. Department of Labor, Employment and Training Administration, or ETA, or the federal, state, or local minimum wage. Employers must pay the offered wage throughout the entire period of employment, and the wages must be paid free and clear. This means that employers cannot reduce the wages paid through deductions or kickbacks. Lastly, on this slide, wages must be paid at least biweekly. I'll pause here in case there are any comments or questions that have come up.
No questions in the chat so far.
All right, thank you. Okay. Ordinary home-to-work travel, commonly known as a commute, is not work time. However, travel between job sites is work time. If an employee is required to report to a meeting place, such as a shop, to receive instructions, pick up tools or equipment, or to perform other work, the travel from the designated meeting place to the following job sites are part of the day's work and must be counted as hours worked. At the end of the day, if an employee is required to return to the employer's office or job site, the travel back to the office from the last job site is counted as hours worked. Employers must make all deductions required by law. Deductions not required by law must be disclosed in the job order and be reasonable, which for the H-2B program means that the amount does not include any margin for profit or administration fee, and deductions for expenses that are for the primary benefit of the employer, such as uniforms, are not considered reasonable. Lastly, the employer must provide all tools, supplies, and equipment required to perform the assigned duties at no cost to the employer. This includes personal protective equipment and hand tools. H-2B workers abroad must receive the job order no later than when they apply for the visa. H-2B workers who are already in the United States must receive the job order no later than when the job offer is made. Employers must provide or pay for transportation and daily subsistence to the place of employment from the place of recruitment, or reimburse workers for the transportation expenses and daily subsistence when 50% of the job order has elapsed. Employers must provide or pay for return transportation and subsistence if the worker completes the job order or is dismissed early. The employer is always liable for the visa fees and related fees in or before the first work week. Employers cannot have an H-2B worker work outside the area of intended employment on the job order, and employers cannot have an H-2B worker work outside the certified occupation listed on the job order. The employer, agents, and attorneys are prohibited from seeking or receiving payments from workers related to the certification. This includes agent or attorney fees and recruitment costs. Employers must contractually forbid any agent or recruiter from seeking or receiving payments from prospective workers. The job must be a full-time, bona fide full-time temporary position, and full-time for the H-2B program means at least 35 hours a week. There may not be a strike or lockout at any of the employer's work sites in the same geographic area. Employers must post the H-2B workers' rights posters. Employers must provide earning statements to each worker on or before each payday. And employers must keep required documents for 3 years. Employers under the H-2B program agree to cooperate with Wage and Hour Division investigators. Employers must notify ETA and Department of Homeland Security in writing within 2 days if an H-2B worker separates prior to the end date. Employers cannot retaliate against any person exercising their rights under the H-2B program. And employers must comply with all applicable laws, such as the overtime requirement under the Fair Labor Standards Act, or FLSA. The typical process for a Wage and Hour Division investigation or compliance review is to meet with the owner or representative for the establishment, request and review records, conduct confidential interviews with U.S. and H-2B workers, and hold a final conference with the employer. A determination letter is also sent at the end to the employer from the district office. If there are violations that result in wages due, the Wage and Hour Division will supervise payment of the unpaid wages. The agency will seek release, instatement, or reinstatement for improperly laid off or rejected U.S. workers. The agency may assess civil money penalties. I will note here that back wages or unpaid wages are wages that should have been paid and are paid to the workers. Civil money penalties here are commonly understood or known as fines, and those monies go to the U.S. government. And employers, attorneys, and or agents may be debarred for up to 5 years. Lastly, the Wage and Hour Division may recommend that ETA revoke current certification. And as before, the public is welcome to call our office and ask questions or discuss concerns. Locally, the Detroit District Office telephone number is 313-309-4500. And we should probably pump that in the chat. And we'll open it up to any questions or discussion.
Now's the time for questions if you have any. And if you think of any questions after we're done today, feel free to shoot them over our way via email and we can get those answered for you as well. But last call for questions via chat, or feel free to unmute and ask any if you haven't. Okay, seeing and hearing none. Thank you guys so much for logging on either for the first time today or again for our H-2A and H-2B trainings. We really appreciate your time and taking the time to log on and do some learning today. I really appreciate that. Thank you to our trainers, Ricardo and Ginger. We really appreciate your guys' time and putting together these presentations. Again, I will be following up via email with both a copy of the presentations and the recording today. But thank you guys so much. You've got some time back into your days, and if there's anything that I can do for you or we can do for you, just let us know. Thank you for logging on.
Thank you.
All right, thank you, everyone.
We did get a question from Eric if he's still on here. Is he still on here? I don't see him. Do you guys see that question in the chat? Because I can add that to
Yes.
Yes.
our follow-up email because I'm not sure if Eric is still with us.
Yeah, he's actually referring, and I don't know if Cynthia's still on, but with their state labor exchange system, if there's been any referrals recorded.